One of the main goals of a privacy program is to be compliant with data protection laws and regulations. The privacy professional must know which laws and regulations apply with regard to the personal information that the organization processes. There are 3 different types of regulations. Most countries have comprehensive laws that govern the processing of personal data in general. For example, the GDPR or the Privacy Act in Australia. In other jurisdictions, privacy and data protection regulations may be laid down in sectoral legislation, like in the U.S. In addition to laws, there are also various codes of conduct. The best known of these is the Payment Card Industry Data Security Standard for Protection Credit Card Data. We will now discuss the GDPR in more detail. The GDPR focuses not only on the EU, but also data processing outside of it. The GDPR has quickly become the new standard, and every privacy professional will have to understand the basics. We will now briefly discuss the first 3 articles. Article 1 is about the objectives of the law itself. The purpose of the GDPR is to find a balance between the free flow of data and the protection of the fundamental rights and freedoms of those to whom the data relates. Article 2 defines the scope of the GDPR. This article shows that the law applies to almost all forms of processing personal data. An important exception is processing in the context of household use, that is not covered by the GDPR. Article 3 defines the territorial scope of the GDPR. This shows that the GDPR also applies outside the EU. For example, if data from EU citizens is processed or behavior in the EU is monitored. The GDPR contains several rules and options for transferring personal data outside the EU, such as the adequacy decision. The EU determines if a non-EU country has an adequate level of data protection. If that is the case, the data may be sent to that country. When there is no adequacy decision, appropriate safeguards that protect cross-border personal data transfers should be in place, like standard contract clauses. If standard clauses are used, the transfer must be assessed in advance. This assessment is called a Data Transfer Impact Assessment. The IAPP has made recommendations on how to conduct such an assessment.